Good morning, good evening, good afternoon. Let's see if and when I go live. And let's see if I have audio, because that would be great to have audio. Good morning, good evening. Not really a whole lot of boomer action going on today. Let me do a thing. And let me go to, I guess I could go to my YouTube channel and pull up the stream so I could see comments, because this time I actually took the time to set up a second monitor. And okay, uh, good morning or good afternoon, Fletcher Boy, depending on what time zone you're in, I guess. All right, so I have chat, and I'm going to do live chat that way. All right, so good morning, heaven backwards. Good morning, freaks. Okay, so as you could probably hopefully see on your screen, we've got Springer versus the 7th Judicial District Court. Now, I skewered the hell out of this case from the get-go. The attorneys were incompetent on both sides of the aisle, and I made several predictions. And after the oral argument, I sensed which way the wind was blowing, and in fact, the wind blew exactly the way that I anticipated it would. So we've got the order and judgment. Plaintiff James Springer appeals that this is James Freeman, by the way, for those of you who don't know, and his attorney was A. Blair Dunn. Plaintiff James Springer appeals the district court's dismissal of his complaint against the state court and 4 individuals sued in their individual capacities, 2 judges on the court's executive officer, and a court clerk, the individual defendants. Springer asserted claims for declaratory and injunctive relief arising under 42 U.S.C. 1983 and a state law claim under the New Mexico Civil Rights Act, New Mexico Statutes annotated 41-4A-1 et sequitur. Section 1983, however, does not authorize claims for injunctive and declaratory relief against individuals in their personal capacities. Boom. And claims against the state court are barred by sovereign immunity under the 11th Amendment. Boom. Exercising discretion under 28 U.S.C. 1291, we affirm the dismissal of the complaint by the United States District Court for the District of New Mexico. So it just fascinates me that a first-year family law attorney out of California can look at this case that was done by a gentleman who is an attorney in New Mexico who has done a number of cases in the 10th Circuit and 10th Circuit Court of Appeals cases. And I can look at it and I can be like, oh, bro, good luck. You're done. Have fun. But I'm just a first-year family law attorney. And A. Blair Dunn, I mean, he's just amazing. I mean, he knows all about the Federalist Papers and the Founding Fathers, and he's a big advocate for folks like James Freeman. And I'm just sitting to myself thinking, does that make him a good attorney? Hmm. Hmm. I mean, if a first-year family law attorney out of California can see this coming, why couldn't he? Why couldn't he? Greetings, WTT. I hope you got your dick out like normal. He's always fapping to me because he thinks that I'm pretty. On review of the district court's dismissal, we accept as true the well-pleaded factual allegations of Springer's second amended complaint and also consider the contents of the exhibits attached to the complaint and incorporated by reference. Springer is a self-described independent investigative journalist who produces social media content intended to expose government fraud, waste, and abuse. Well, I think that James Freeman's intent is that, but I think generally he exposes himself as being a narcissistic asshat who doesn't fucking understand what he's talking about or dealing with. Every time you turn around, James Freeman has some explosive, crazy, oh my God, I can't believe they did this bullshit. And if I bother to watch, which I seldom do because it just infuriates me normally, it's always just normal. It's always just normal. Don't get excited. The DMCA lawyer, the I'm not really delving deep into the FT case. It's going to be more of a passing observation, more of an I told you so. Chief Judge Mercedes Murphy of the New Mexico 7th Judicial District Court issued an administrative order banning Springer from entering the Torrance County District Courthouse unless he had specific court business and was escorted by law enforcement. The administrative order was delivered to Springer with a letter from the 7th District Executive Officer, Jason Jones, which stated that Springer had harassed court staff. A few weeks later, Chief Judge Murphy entered an amended administrative order covering other courthouses in the 7th District after Jones reported that Springer had been disruptive and threatening in a second courthouse. Must be a pattern. Must be a pattern. After the amended administrative order was issued, Chief Judge Murphy and Judge Shannon Murdoch Poff prevented Springer from attending public hearings in person and by video. And clerks, oh, come on, you're a district court judge. Why would you start off a sentence with and? Why? Clerk Susan Rosendahl did not allow Springer to inspect public records in the clerk's office and required police presence when Springer entered the courthouse. Also, Rosendahl, acting at the direction of Chief Judge Murphy, falsely, this is the allegation that Springer made and they're taking it as true, reported to the New Mexico State Police that Springer was an armed threat, and all defendants conspired to have YouTube remove one of his videos. Well, let's see. In another case that A. Blair Dunn lost for Freeman recently, I think in October, September or October, it was Springer versus, I forget the name of her, the governor of New Mexico, challenging an order that prevented people from concealed carrying in parks and some other places. And yes, A. Blair Dunn lost that one, and yes, Freeman lost that one, and who didn't see it coming? Apparently Freeman and Dunn didn't see it coming, but I'm pretty sure that everybody else saw it coming, or at least I saw it coming. But in that, Dunn argued that Springer was in violation of the Second Amendment, prevented from carrying at these places, which implies that Springer carries, which I mean, he should. I mean, people should. That should be the norm. It's a dangerous world out there, and if more good guys carried guns, there would be fewer bad guys with guns left alive to cause problems. The second amended complaint asserted 4 counts. 1, a First Amendment viewpoint discrimination claim brought under 42 U.S.C. 1983 against Chief Judge Murphy and Judge Murdoch Poff, a First Amendment retaliation claim brought under 42 U.S.C. 1983 against all defendants, 14th Amendment due process claim brought under 42 U.S.C. 1983 apparently against only the individual defendants, and 4, a claim of violations of the New Mexico Bill of Rights brought under the New Mexico Civil Rights Act against the 7th District. Springer sought declaratory and injunctive relief against all defendants and damages from the 7th District. Michael White says, just kidding, Merb, wasn't that one of what your detractors used to call me? Specifically, James Freeman started John's or Merb is just a first-year family law attorney. And indeed I am. And I am proudly a first-year family law attorney. And I wear it with pride because unlike some people, like say, for example, RC, who like stretches his asshole out about how big of a dude he is, about how big and badass, and he represented Carl's Jr. in some sort of a lawsuit, or he didn't actually, I don't know if he said he represented him. I think he was on the case for it. And how he had to memorize over 4,000 specific facts or something like that in a case. I mean, you're a good attorney if you fucking understand your limitations. You stay inside your lane of what you know and what you don't know. That's absolutely true, Dan Fizel. Absolutely true. That's blood libel, by the way. You're being anti-Semitic, I think. So yeah, that's what in my opinion, that's what separates a good attorney from a bad attorney is sticking in your lane, saying you know what you know, saying you don't know what you don't know, and only opining and interfering in things where you can give an educated opinion. You can be wrong, and that's fine. That doesn't make you a bad attorney, but you ought to be able to at least see clearly deficient pleadings. The district court dismissed the complaint but granted Springer leave to amend counts 1, 2, and 3 to name Chief Judge Murphy in her official capacity, which was important if you're seeking declaratory relief. You have to be suing the the state official in their official capacity, because essentially the state official is standing in for the state at that point, and you're trying to get the state to do something. Springer appealed the dismissal, but we have dismissed the appeal for lack of a final order. But we initially dismissed the appeal for lack of a final order. Back in district court, Springer announced his intention to stand on the Second Amendment complaint and requested a final judgment, which the district court issued. He then filed this appeal. We reviewed de novo, which means basically they don't really care what the district court opinion was. They're going to review everything with fresh eyes. The dismissal of a complaint for failure to state a claim, see Commonwealth, blah, blah, blah. We determined whether the complaint sufficiently alleges facts supporting all the elements necessary to establish an entitlement to relief under the legal theory proposed. We also reviewed de novo a district court's determination of state sovereign immunity. On appeal, we can affirm the district court's ruling on any ground adequately supported in the record. We addressed Springer's claims against the judges and employees first, then we addressed the claims against the 7th Judicial District. So the individual defendants, in the 3 counts against the individual defendants, Springer sought declaratory and injunctive relief only for actions taken individually under the color of law. The district court read the Second Amendment complaint as suing the individuals only in their personal capacities, and Springer has not contested that reading. Yet, under Section 1983, a plaintiff cannot sue an official in their individual capacity for injunctive or declaratory relief. And I believe I have cited that particular case before in one of my reviews. You can, of course, go back and see that for yourself. Because we hold that the claims were improperly asserted against the individual defendants in their individual capacities, we need not address the other grounds relied upon by the district court in dismissing counts 1, 2, and 3. And I remind you that there were many. What the district court is saying is that based on this alone, we don't even have to go in and review the rest. And they don't. That doesn't mean that the other grounds relied upon by the district court aren't sufficient in and of themselves. The district court the Court of Appeal just said, yeah, I mean, it's done at this point. We don't even need to review anything any further. Then against the 7th Judicial District. Springer also asserted a claim against the 7th Judicial District. The 11th Amendment, however, implicitly recognizes state sovereign immunity, which ordinarily bars federal court jurisdiction over private suits against the state by citizens of the state. 11th Amendment immunity applies regardless of the nature of the relief sought. This rule extends to arms of the state. New Mexico district courts, including the 7th Judicial District, are arms of the state, and so they are entitled to sovereign immunity. 11th Amendment immunity can be overcome only if, number 1, it's abrogated by Congress, or 2, waived by the state. Springer argues that both of these exceptions to immunity are satisfied here. He is incorrect. First, Springer contends that Congress abrogated state sovereign immunity by enacting 28 U.S.C. 1367A, which provides a federal district court with supplemental jurisdictions over state law claims that are sufficiently related to claims in the case that are within the original district jurisdiction of the federal court. But the Supreme Court has declared that supplemental jurisdiction statute, quote, does not extend to claims against non-consenting state defendants, end quote. That's an old case, 2002. That's over 2 decades old. Like, I don't know how Dunn didn't know that, didn't find it. I mean, all I did, I didn't even look specifically for Supreme Court cases, but when I reviewed this, I looked up federal district court cases in New Mexico and 10th Circuit cases. That's all I did, 10th Circuit Court of Appeals cases. And I looked for the particular issue, the suing under the New Mexico Government Torts Claim Act. And I looked at how every single district court case and Court of Appeals case that dealt with the specifically New Mexico Government Tort Claims Act dealt with bringing that cause of action in federal court. And every single one of them said, no, you can't do it. And they all referenced Ragour versus Regents of University of Minnesota. I mean, if he had done 10 minutes of research. If Dunn had done 10 minutes of research, 10 minutes of research, he'd have been like, I'm fucked on this one. But he didn't do it. Why didn't he do it? I don't know. Maybe he's a bad attorney. Maybe he was just busy. Maybe he assigned it to an underling a la RC, and the underling effed up. Maybe the underling's a bad attorney. But I would expect a good managing attorney, a good lead attorney would look up citations, would double check. I mean, nothing that Dunn has shown me has given me any indication that he's a good attorney. And I don't mean to be disparaging, but like proof is in the pudding. Like if this had been a close case, if there had been an arguable precedent on his side that he could have cited to and he didn't, then I'd have been like, okay, well, this is a good question of law for the Court of Appeals to kind of look at both sides and figure out which way they're going to go. But there wasn't anything. There was literally nothing supporting his, Federalist Papers and misquoting that Virginia Supreme Court case that went to the United States Supreme Court where there was a bar issue. Second, Springer argues that New Mexico waived immunity. The test for whether a state has waived immunity from federal court jurisdiction is a stringent one. Waiver must be unequivocally expressed, and the scope of waiver is, quote, strictly construed, end quote. In particular, a state's consent to suit in its own court is not a waiver of its immunity from suit in federal court. And again, all the cases I looked up on the New Mexico Government Tort Claim Act, all of them said the same thing. And they all cited a Atascadero State Hospital versus Scanlon. Instead, the waiver must specify the state's intention to subject itself to suit in, quote, or in emphasized federal court. So it has to say you can get sued in federal court. Springer contends that Section 41-4A-9 of the New Mexico Civil Rights Act contains the waiver. The act, quote, creates a private right of action to enforce the rights guaranteed under the Bill of Rights of the New Mexico Constitution. That's quoting a New Mexico case. It provides, the state shall not have sovereign immunity for itself or any public body within the state for claims brought pursuant to the New Mexico Civil Rights Act. I was saying the New Mexico Government Tort Claim Act, but it is the New Mexico Civil Rights Act, my bad. And the public body or person acting on behalf of or the color of or within the course and scope of the authority of the public body provided pursuant to the New Mexico Civil Rights Act shall not assert sovereign immunity as a defense to a bar or action. As noted above, however, to waive 11th Amendment immunity in federal court, a state statute must specify the state's intention to subject itself to suit in federal court. Again, the emphasis there. Thus, a general waiver of sovereign immunity, apparently indeterminate in its scope or locus of effect, is insufficient. 10th Circuit ruling, which I believe I read. Yet, 41-4A-9 is no more than such a general waiver. It says nothing about suits in federal courts. The statute falls short of the unequivocal expression that federal law requires to find the state waived 11th Amendment immunity in federal court. Finally, we note that the district court addressed the state law claim even though all the federal claims were being dismissed before trial. This was not necessary. District courts may decline to exercise supplemental jurisdiction over a claim if, quote, the district court has dismissed all claims over which it has original jurisdiction. If, quote, the district court has dismissed all claims over which it has original jurisdiction. All right, and it would generally frown on the practice of resolving supplemental state law claims after the federal claims have been dismissed pre-trial, largely because of the concerns of comity and federalism. Here, however, the district court dismissed the state law claim on federal law basis, immunity under the 11th Amendment. Comity and federalism are not implicated. The dismissal by the district court was eminently proper. We note that the dismissal on this ground does not foreclose bringing the claim in state court. For the foregoing reasons, we affirm the district court's order dismissing the case. Boom. First-year family law attorney vindicated again. Now, out of deference to Randall, I'll address the Frauditor troll issue. It was, I believe, second on the list of things I was intending to cover anyway. About 4 months ago, I made a video about Schadenfreude. And in that video, I made two predictions that have already come true. Number one, the Frauditor troll would be found. You aren't hiding from him. There's going to be a trail. And Frauditor troll was found. Frauditor troll was found and he was served. So prediction number one, yes, I'm a fucking genius. Merbstradamus. Prediction number two was that he was going to start a GoFundMe and he was going to milk his subscribers. And that prediction has also come through. I have had it verified to me through multiple reliable sources that there is in fact a GoFundMe. No, I'm not going to link it because I don't want to give it any advertisement, but he is in fact milking his subscribers. Now, because Randall is here, I'm going to make another prediction. This case is going to end up in getting resolved at one of 2 points. I don't think it's going to trial. Cases like this seldom go to trial, and I don't think there's going to be any real good reason for it to go to trial. My prediction is that number one, it will either get resolved on a motion to dismiss brought by the defendants. I'm not good enough on the law, specifically copyright law, to give a qualified opinion on whether or not I think they're going to prevail. My best guess is probably not. There's going to be at least one issue preserved after the dismissal, but that's just a wild ass guess. So, don't hold me to it. And if it doesn't get resolved at that point, the parties are going to settle using the money that Frauditor troll has been milking from his subscribers. And for every single person in the comment section of that Schadenfreude video who said that number one, he won't be found, and number two, he won't start a GoFundMe, well, I 100% was right and you were 100% wrong. And now Frauditor troll is saying that he's going to fight this to the bitter end. And I'm going to suggest that that is bravado and that he won't fight this to the bitter end. And if his attorney loses on the motion to dismiss, his attorney will probably at that point inform him of the potential costs, allegedly, and of course no receipts, because why would anybody provide receipts for these things? And I'm not even saying you should. I think it was a mistake for Kate Peters to provide billing statements from her attorney. And it's also, generally speaking, not a good tactic to inform the defense over how much you have managed to milk from your subscribers, because that will give the plaintiff an idea of how much money you have available to settle. But I do think that Frauditor troll is going to come to grips real soon with how much his expensive boutique lawyer is going to be. And it's going to be an hourly case. I am 99.99% sure that the attorney isn't doing it pro bono, and 99.99% sure the attorney isn't doing it on the promise of potential attorney's fees that might be awarded if they're successful. So I'm just going to go and, if you fail on the motion to dismiss, at that point, there is a lot of risk and not a lot of reward in going to trial. So that's that. So Peyton's Fivehead says, "Well, I remember Frauditor troll saying himself he had a lot of money set aside for lawsuits. He 100% expected to get sued from the start." Well, that was an accurate prediction from him. Whether or not he has a lot of money set aside, who knows? Earl's still going with money he set aside from YouTube. Apparently, if you can get enough subscribers and get enough Patreons and enough GoFundMes and whatnot, you can do pretty well. So there you go. All right, so then we have Mets. Now, the Mets is Rogue Nation, and I shit all over this one from the beginning. Mets rubbed it in my face when the initial report and recommendation for dismissal on the merits was set aside by the district judge, because the magistrate made the recommendation and report. It goes to the district judge if one of the parties is dissatisfied with it, and in this case, it's the defendant has never answered. So I just want to go over the complaint real quick, so that we can kind of see what's going on. So, basis for jurisdiction, this is a federal question. It's a 1983 lawsuit. And then down here, he says, Officer Smith, this is a statement of claim. Get down, kitty. Officer Smith violated my First, Fourth, and Fifth Amendment rights as well as committing prior restraint and First Amendment retaliation, statement of claim attached. What he's seeking is punitive damages. He doesn't list compensatory damages or nominal damages. That isn't necessarily mean that he will never get them. But he says this was a willful and knowingly, a, a willful, a willful and knowing violation of my rights. I had the law in my hand, and he refused to read it or understand it. Well, obviously, if he refused to read it, he would never understand it. So Warren Monkdale says Rogue Nation will never win a case. Well, I don't know about that. If you consider a settlement a win, I know he has settled at least one case. So how much he got for it, I don't know. But the value for a lot of these nuisance cases are in just getting a settlement. Going to trial is risky, and especially for someone like Rogue Nation, who most people outside of the auditor supporters don't like. Um, I would think it'd be very risky for Metz to go to trial. I wouldn't anticipate him getting a sympathetic jury. Dan Fizzle asks a little less blood libel in this question. Well, that remains to be seen. And it kind of goes to this case. Do you think AI is opening up courts to more pro se lawsuits such as this, or is two steps backwards? Well, let me tell you a little story. I had a case, a guy wanted to sue. Well, a guy wanted to sue. And so uh, I gathered all the facts from him and I prepared a complaint based on the facts that he gave me and making sure that I could allege facts that, if true, would establish and prove each element uh, of every element of the cause of action that I pled. And I sent it to him, and he sends me back a Chat GPT lawsuit that has, I think, 3 additional causes of action. I use that term in scare quotes because, well, none of them were causes of action. And I had to spend his money, my time, his money, on going through and trying to figure out what he was referring to. It looked like ChatGPT, but I can't prove it. It was probably some AI, but I don't know which one. And I found the things that were the closest, but he didn't even allege all the causes of action that I mean, that whatever ChatGPT-esque program he used didn't even properly allege all the causes of action that it thought were causes of action. So I went through and I tried to find causes of action that most closely approximated was what he was talking about. I explained to him in exhausting detail why each cause of action didn't exist that he was alleging. And so then a few days later, I get back another complaint from him again with more Chat GPT causes of action. And like, it was shockingly wrong, shockingly wrong. And so while, yes, I do expect chatbots to make pro se litigants feel much more uh, competent than they really are. The problem with these, I think they call them like large language models or something like that. They're not really AI. They're not really intelligent. And the best analogy I've heard, I don't use them, but the best analogy I've heard is if you already know the subject matter, they might give you a good starting point to look for something. But they don't know enough. They don't understand it. They don't have an actual understanding. And what they give you back is based on what you put in. And so if you don't understand the things that you're asking for, you're going to ask a bad question, which means you're going to get a bad answer, garbage in, garbage out. And it doesn't know enough to winnow through the chaff to find the wheat. So going away money to me is not a win, says Warren Monkdahl. Well, that's not a win to you, but But it's always weird. Anti-auditors, let's call them anti-frauditors because that's more the name that they like to give themselves, have this weird binary position that like they're conflicting positions. Number one, the auditors are only in it for the money, and number two, it's not a win if they get money. Like that's a fucking retarded position to take. It's either one or the other. If they're only in it for the money, getting go away money is a win. If they're not in it for the money, well, then maybe getting going away money isn't a win to them, but they agreed to it. They literally they signed the settlement agreement, so they must think it's a win. And you're not a psychologist, and you haven't like sat down and analyzed their innermost desires. But I'll bet I could make a educated guess based on the number of auditors who've contacted me about their wins, which were settlements. They thought they won. They were every last one of them was proud as a peacock. Ha, you said I didn't have a case and I got a settlement agreement. Well, great. You still don't have a case, and the amount of money you got is a lot less than the government would have spent to on attorney's fees. But yeah, sure, to you it's a win. Congratulations. All right, so he wants back to Metz. He wants punitive damages of $200,000. He says it's willful and knowing. He says he had the law in his hand. Whether or not he did, that's he doesn't explain what law. Oh, so we're going to continue arguing. Okay, Monkdal. So they claim to be activists, right? So, but you claim they're motivated by money. So, I mean, they might be hypocrites, but you're also a hypocrite. So, congratulations on noticing their hypocrisy, but look at your internal conflicting opinions. You're maintaining two things in your head that directly conflict with each other. They directly conflict. That's you being stupid, for lack of a better term. And when asked to provide statute numbers of the laws he was claiming applied, he refused to do so. WCD claims they're motivated by meth, and, in Rogue Nation's case, possibly. Peyton's Fivehead says getting money and changing law is not mutually exclusive. In fact, some of the settlements that I've seen have required the city to, or at least one of them that I remember, required the city to implement a new training regime to address the alleged situation. So, I mean, that didn't get the law changed, but it got the policy changed. So, would that be a win? All right, let's see. All right, so he says he's of legal age. Smith was employed as a police officer. Varnell is a municipality, and Smith is sued in his individual capacity only. That entitles him to get money damages. So Metz was in Barnville to record the public employees of the Hampton County, South Carolina Health Department. Why anybody would do that still fucking boggles my mind. Why would you do that? That's not holding someone accountable. That's just being an asshole, but that's my opinion. And reasonable people can have differing opinions that are reasonable. I don't necessarily think that auditors are in general reasonable. There are some, but I would not count Rogue Nation, who I like. You know, I don't dislike him necessarily, but he's not a reasonable person. He is the king of Dunning-Kruger, as far as I can tell. He says, having arrived close to the end of the day, there were no citizens in the lobby. Within 2 minutes of me entering the building, I was accosted and told I was not allowed to film. At 7 minutes into the video, I walked outside to continue filming through the window as they were closing for the day. At 8:27 in the video, Officer Smith arrives and tells me I'm not allowed to record in the building. At 8:56, so this conversation has been going on for a half hour. Smith states I need to show him something that says I can record or else I have to leave or face arrest. In the video at 9:10, so they've been doing this for about 40 minutes. Smith instructs him to shut down his video recording. Lucky for me that my body cam was running, he don't notice it, or else I wouldn't have been able to catch his later violations. At 11:33, oh no, these are minutes. Never mind, this isn't time. So Only a few minutes. My bad. My mistake. At 11:33 in the video, he threatens me with arrest if I don't provide physical ID. At 13:54 in the video, he threatens me arrest for taking the fifth and not answering his questions. But did he arrest you? But did he arrest you? What are your actual damages? So far, I don't see any. Fourth Amendment claim. He did unlawfully seize my ID without reasonable or even arguable reasonable suspicion. The crime had been committed as a trespassing statute doesn't apply to public property. That is a legal claim. Uh, but he also didn't arrest you. And could he have been making a mistake of law? Yes, he could have. You haven't established yet that Officer Smith was being willfully, uh, I forget the elements for it, willfully, fraudulently, blah, blah, blah. There's like three different elements. I forget them off the top of my head. I'm a bad attorney. Claim two, he violated my First Amendment right by forcing me to leave a public area that I was legally allowed to be at for recording. I don't know if that's a First Amendment claim. Maybe. Just because you're legally allowed to be at an area does not mean that you're legally allowed to record in the area. And a court is going to know this because courts can and do limit recording at public hearings. So even though the public is allowed to attend, they're not allowed to record. So again, this is just Metz in his ignorance, thinking that because he's legally allowed to be there, he's legally allowed to record there. And if he's recording in violation of a policy, rule, whatever, then they can ask him to leave. They maybe even be able to tell him to leave. They may be even able to arrest him for failing to leave. Fifth Amendment claim, Smith violated my Fifth Amendment right by threatening me with arrest if I didn't answer his questions after I invoked my right to remain silent. Well, did he though? Did he though? Because you invoked your fifth, he threatened you with arrest. There's nothing that I'm aware of that prevents him from saying things, lying to you to get you to do things. Again, officers can and do lie to you. They can, do, and will lie to you. There's nothing in the law that I'm aware of that prevents them from lying to you. And if they can get you to willingly do something, like, say, for example, hand him your ID by saying, I will arrest you if you don't, that's not him seizing it. You have handed it to him. You have handed it to him. Under time, place, and manner, the manner is the rules of the building. Why are you applying time, place, and manner? It's a it's a non-public forum. Why would you start there, Monkdall? It's a non-public forum. Unless you're of the opinion that a Hampton County, South Carolina health department is a fucking public forum. Like what? Time, place, and manner. I learned three things. Like, come on, Dunning-Kruger, pull your head out your ass. Oh, and that's it. So the First Amendment retaliation claim, I don't see it particularly. He has every right to approach and talk to a citizen, unless, so you might get him if you say, well, he detained me, but you were not willing to leave. It's the opposite of detained. And I love this claim. I think this is claim 5, claim 4. Metz has a stellar grasp of Roman numerals. Claim 4 would be IV. Claim 5 would be just V. But, he's writing books, by the way, just so everybody can be aware. Metz is now an author who's writing psychology books. I haven't read it, but I'm sure that his psychology books are just as stellar as his complaints for relief. I'm sure they're just as stellar. All right, so then here's the report and recommendation. The matters before the court on plaintiff's motion for default judgment, plaintiff proceeding pro se and in forma pauperis, filed this action because, of course, the taxpayer should should have the burden of paying for Metz's nonsense. Now, Metz will tell everybody in my Discord about how he's making good money, and he has sponsors and patrons. I don't know if he has Patreons, but he has patrons, and he does very well for himself. And yet here he is pleading informal pauperis. Like, why does the taxpayer have to shoulder this burden? We can't even afford to pay SNAP benefits for people who allegedly can't afford to feed themselves. And here we are paying for the time waste that is this case. The undersigned magistrate judge is authorized to review all pretrial matters in this case filed under 1983 and submit findings and recommendations to the district court. Plaintiff commits this action by filing a complaint against the defendant pursuant to 42 U.S.C. 1983 on December 14th, 2023. The United States Magistrate Judge issued a report and recommendation on April 12, 2024, recommending the district court dismiss this action with prejudice, without leave to amend, and without issuance and service process. The district court issued an order adopting in part and declining to adopt in part the report and recommendations. The district court concluded that plaintiff had failed to state a plausible claim for relief as to his Fifth Amendment claims, but alleged sufficient facts to survive initial review as to his First and Fourth Amendment claims. So remember, the federal court is ostensibly a notice-based pleading. I mean, you've got Twickball, Twombly and Iqbal, where you have to allege sufficient facts to put someone on notice as to like the kind of more specifics of your claim. And maybe this survives Twickball. Maybe it does. But the issue then is if they don't respond, if there's a default and you're left just proceeding on the complaint, on the issues that are raised in the complaint and the facts that are alleged in the complaint, then you have a issue for default judgment, because at default judgment, all of the well-pleaded facts in the complaint are taken as true. Now, that doesn't include things like Smith violated my rights. Well, that's a conclusion of law. But he ordered me to cease recording is a fact that would be accepted as true. And so the court does two things. First of all, the court figures out at the default judgment stage, not the default stage, but the default judgment stage, whether or not there is actually a cognizable claim for damages that has been pled in the complaint. And then, and so if you can establish liability in the complaint, then the judge will look at damages. Now you're limited, the maximum amount of damages you can get are what are pled in your complaint. And there is a question about whether or not Metz is entitled to compensatory and or nominal damages because he didn't specifically plead them. Now I think you can get around that by I think a court can still give you nominal damages even if you fail to plead any damages, but nominal damages is like $1. So yay. And generally speaking, like you can get, so generally speaking, your punitive damages are limited. In most cases, you're limited to pretty much single figure punitive damages. Now there's a 3-part test that the court will have to go through that looks at various different things. But generally speaking, a court is on safe territory by ordering single digit punitive damages, or jury, single digit multipliers for punitive damages. So like, 9 times your actual damages, so if you get like $1,000 in actual damages, then maybe you'll get an additional $9,000. Now, in 1983 cases, that's a little bit more relaxed, but again, this is dependent on how reprehensible the actions taken by the person are. But you could go up to I've seen awards like $35,000 on a $1 nominal damage award, but you're not going to get up into the $100,000, $200,000 range. So if Mets, if the complaint sufficiently alleges specific actions, facts, not conclusions of law, but facts that show Smith acted in a reprehensible way, then Mets may be entitled to punitive damages. But again, it probably, in the grand scheme of things, won't be a lot. I mean, $5,000 maybe would be somewhere in the ballpark, maybe, maybe. The district court recommitted the matter to the United States Magistrate Judge for further evaluation and issuance of service of process. The matter was assigned to the undersigned United States Magistrate Judge on March 18th, 2025. So this is the second judge, magistrate judge, I believe. So it was a different magistrate judge that entered the initial report and recommendation, and now it's to this magistrate judge. So we have two judges magistrate judges, who both seem to think that the complaint is severely lacking. The serve order, summons, complaint form, blah, 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 were forwarded to the United States Marshal Service for service process. On April 29th, the Marshal Service filed a summons returned unexecuted. The USMS attempted to serve the defendant at the address provided by the plaintiff, but the USMS could not accomplish service. The undersigned issued a proper form order to provide plaintiff with an opportunity to properly identify defendant and or provide a better service address and submit properly completed service documents. Plaintiff filed a proposed summons in form USM 285, and the undersigned issued a second serve order. In May of 2025, the USMS filed a summons return executed on July 11th, indicating it personally served defendant at the address plaintiff provided. Defendant's answer was therefore due by July 30th. Defendant has not filed an answer or otherwise responded to plaintiff's complaint. On August 11th, plaintiff filed a request for entry of default. The clerk of court filed an entry of default on the same date. The clerk's entry of default was mailed to the defendant's address. On August 25th, plaintiff filed the instant motion for default judgment. This motion was also mailed to the defendant's address. Defendant has not appeared to file a response. The matter is now ripe for review. Plaintiff alleges he is a, quote, independent journalist / activist, end quote. We went to Varnville, South Carolina on May 26th to record public employees of the Hampton County, South Carolina Health Department. Plaintiff alleges he arrived at the department's building close to the end of the day. Plaintiff contends that within 2 minutes of entering the building, he was accosted and told he was not allowed to film. Plaintiff subsequently walked outside to continue filming through the windows because the department was closing for the day. Plaintiff alleges that defendant, a police officer employed by the city of Varnville, arrived and told him he was not allowed to record in the building. Plaintiff alleges that defendants say the plaintiff needed to show him something that says he can record, or else plaintiff had to leave or face arrest. Plaintiff submits the defendant asked him to shut down his video recording, but he continued recording with the body cam that defendant didn't notice. Plaintiff alleges that defendant threatened to arrest him if he did not provide physical identification. Plaintiff alleges he exercised his Fifth Amendment rights to not answer defendant's question. And defendant again threatened to arrest plaintiff. Plaintiff alleges that his Fourth Amendment rights were violated because defendant unlawfully seized his identification without reasonable suspicion. Plaintiff also alleges his First Amendment rights were violated when plaintiff forced him to leave a public area for recording. Plaintiff seeks punitive damages, $200,000. Plaintiff explains that this was a willful and knowing violation of my rights. I had the law in my hand and refused to read it or understand it. When asked to provide state statutes of laws he was claiming applied, he refused to do so. So this is the law and analysis. Upon a showing the department against whom a judgment is sought has failed to plead or otherwise defend, a clerk must enter the party's default. After the clerk has entered a default, the plaintiff may seek a default judgment. The court may conduct hearings. When to enter or effectuate judgment, it needs to A, conduct an accounting, B, determine the amount of damages, C, establish the truth of any allegation by evidence, or D, investigate any other matter. So the court gets to look into it. The court gets to see if the court actually wants to basically allow damages in the first place, and then the court gets to figure out the amount of damages. In considering a motion for default judgment, the court accepts as true all well-pleaded factual allegations in the complaint not relating to the amount of damages. Now that is important, all well-pleaded factual allegations. So this is where having an attorney prepare the complaint, normally, maybe not in the case of A. Blair Dunn, but where having an attorney prepare the complaint is normally of benefit to the litigant because the attorney should and is more likely to prepare a well-pleaded, factual, allegation-based complaint. Monkdahl says, because he's a fucking legal genius, I say that with as much sarcasm as possible. Good to see you, Devin. He says, isn't a healthcare facility not also protected under HIPAA? Yeah, does HIPAA apply to non-insurance company and medical care provider companies? Pretty much no. I'm not bound by HIPAA. HIPAA places burdens on the healthcare providers and the healthcare insurance providers to protect the personal information of the patients. I'm asking, not telling. And so, no, it doesn't apply to Mets. Now, the the health department of South Carolina, Huntsville Division, or whatever, is bound by HIPAA, probably, assuming it does what I think it does. And based on that, they have an obligation to do things like have policies in effect that prevent people from recording. Yeah, Devin's right. HIPAA applies to the people who have the records. So it could be a HIPAA violation if the health department, assuming they're dealing with patient records, allows a third party to come in there and view them. It wouldn't be the third party that is in trouble with HIPAA. It would be the health department because they allowed a third party to view protected personal information. So I would hazard a guess, and this hasn't, I mean, it wasn't even pled, which is stupid. He should have pled, Metz should have pled that there is no policy in place at this Department of Healthcare, whatever, that prevents recording. And there's no policy in place that allows the staff and or management of that healthcare department to prevent people from recording. That would be a real useful thing to have pled. I would have pled it. I mean, if it's true. But so you don't even know if, like, because that cop, my best guess is, because this is the way cops tend to work, my best guess is the cop gets a call from dispatch. Dispatch says, yeah, this healthcare department or Department of Healthcare Service, whatever it is, called us. They said they have a guy recording there, and they told him he wasn't allowed to record, and they told him to leave, and he wouldn't leave, or something along those lines. So that's what the cop is going there. The cop is going to assume, because this is what cops do, that, yeah, the people there can kick him out for recording. They probably have a policy on it. And so based on that, I'm going to go do my thing and get the guy out of there because he's obviously a problem. He's obviously a problem, or they wouldn't have called. So that was a big fail on Metz's part. He says, however, a default is not treated as an absolute confession by the defendant of his liability and the plaintiff's right to recover because the defendant is not held to admit conclusions of law. Thus, regarding default judgments, the appropriate inquiry is whether or not the face of the pleadings supports the default judgment and the causes of action therein. Well, the court must accept a plaintiff's factual allegations as true. The plaintiff must still prove that it is entitled to damages. Entitled to damages. Not at this point, we're not even what the damages are, but that the plaintiff is entitled to damages. The Fourth Circuit has a strong policy that cases be decided on the merits. However, default judgment may be appropriate when the adversary process has been halted because of an essentially unresponsive party. In the motion, plaintiff requests the court enter default judgment against defendant and award plaintiff damages for the amount requested. As noted, plaintiff's complaint seeks punitive damages, $200,000. There's a footnote there. The sentence appears to seek $200,000 in punitive damages. It is not clear whether plaintiff is only seeking punitive damages. I thought it was. I think it is. I thought it was, but maybe the court reads it different than I do. Interesting. How do you not read that as? Oh, I see. There's that comma there. He doesn't say punitive damages. So Metz's imprecise language and general Dunning-Krugerishness has, in this particular case, saved him. Because I will bet you that he was looking for $200,000 in punitive damages. But because he stated it so inarticulately, the court's like, well, I mean, maybe he's seeking $200,000, some or all of which is punitive damages. That is a very generous court. Uh, Metz, this court threw you a huge fucking bone. Not in the way you like it, i.e., a bone in your ass, but I mean, a bone. I'm joking. Metz isn't gay. Generally, a litigant may not obtain an award of punitive damages in the absence of the award of compensatory or nominal damages. That is generally the case that I am aware of. But there are exceptions. No, hold on a second. No, I've never seen one. Let me think. There may be exceptions, but I don't know of them. I've I think I've seen punitive damages with nominal, but I don't think I've ever seen them without at least nominal damages. That would be interesting. That would be interesting because if you're not injured, if there's no injury, if there are no damages, that's when you get the nominal damages of $1. I don't know. That'd be an interesting case. If someone knows a case, I'm looking at you, chat. If somebody knows a case where there were punitive damages without nominal damages or compensatory damages, I'd be interested to see it. He says, however, nominal damages need not always be specifically pled. Yes. So, like generally speaking, where this comes up, if someone pleads compensatory damages uh, and they aren't able to sufficiently prove compensatory damages, the court may award them nominal damages, which is even though they didn't ask for nominal damages, they still get the dollar. So, yeah. So that's why you don't always have to plead nominal damages. It's not clear to me that if they're not pleading any compensatory damages, if they're only pleading punitive, it's not clear to me that that means they're entitled to nominal damages. But I would guess since the court is taking this tack that they probably are. We reject Minnesota Mutual's contention that Botsley's failure to specifically plead nominal damages barred an award thereof, particularly when the counterclaim asked for the court to award, in addition to the costs and fees incurred, ... such and other further relief as the court deems just. Well, Metz didn't ask for that, so what about Liberty Mutual Fire Insurance? Nominal damages need not be specifically pleaded where a party alleges a claim for general damages. Aha! 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 The general damage allegation sufficiently encompasses nominal damages. So, assuming the court is nice enough to take Metz's shitty prayer for relief as asking for compensatory damages as well as punitive damages, then yeah, so he might be entitled to nominal damages. The court continues, plaintiff does not appear to plead a prayer for other further relief as the court deemed just or general compensatory damages. However, liberally construing plaintiff's pro se complaint, plaintiff may be seeking actual or nominal damages in addition to punitive damage. That is so generous of this court. Accordingly, the undersigned does not recommend the plaintiff's motion for default judgment be denied on this basis. Oh, that's poopy. That's poopy. I would have. But I'm an asshole. Where was I? There we go. However, plaintiff's motion is completely devoid of any argument or evidentiary support that he is entitled to the damage amount requested in the complaint. That is true. He doesn't plead any harm. He doesn't plead any harm. My right was violated. Well, that doesn't mean you were harmed. Plaintiff is required to prove damages by a preponderance of the evidence following entry of default before the entry of default judgment. A mere generalized statement of the amount due is that in the plaintiff's complaint does not establish a sum certain for the purpose of Rule 55b1. Plaintiff has failed to show he's entitled to the damages requested. He didn't plead facts. He made conclusions, but he didn't plead facts to show that the officer willfully and knowingly violated his rights. He didn't plead facts. And saying that, well, I had the law in my hand, what law? What law? Specifically, what law did you have in your hand that could, would, or should have put the officer on notice? And him refusing to read law provided by a suspect, there's no requirement for him to do that. So you have to, the way normally it's proved is to show like a pattern. Like the officer did this thing, and then, there was some training to correct it that put the officer on notice that he can't do the thing, and then he did the thing again, if that makes sense. So you gotta show that like the officer knew to show it was willfully. Willfully means you know, but you do it anyway. And intentionally, or willfully and knowingly. Yeah, so knowingly. There you go. Willfully and knowingly. Those are two different things. Plaintiff has failed to show he is entitled to the damages requested. Plaintiff makes no argument in his motion and points to no evidence to support his conclusory assertions. Accordingly, the current record does not support default judgment. You haven't pled facts, you dummy. You haven't pled facts sufficient to show there are damages. You haven't pled facts sufficient to show that he did this willfully and knowingly, whatever the fuck that means. Because the determination of damages is dispositive, the undersigned recommends the district court conduct a hearing on the amount of damages to be awarded, if any. If defendant appears prior to an evidentiary hearing, it is recommended that this report and recommendation be vacated and the matter be recommitted to the undersigned for further handling. And indeed, the officer should file an answer. But maybe the officer's like, no, if I file an answer, he'll get a settlement, but if I don't do anything, he probably won't get a dime. And probably since the officer was sued in his individual capacity, I'm guessing that that particular city he works for doesn't pick up the bill for these lawsuits. And since Met's filed in form of pauperis, that is a strong indicator to the cop that even if he does get an attorney fee award out of Met's, that there's a low likelihood that Met's will pay. And in fact, I think there was an award against Met's for something. I don't remember. It wasn't that big of an award. And Met's has flat out said in Discord that he refuses to pay it. So, I can see logic in just not doing anything and cutting your losses. Because I mean, if Met's gets like a $5,000 judgment, that's less than the attorney's fees would be. And then Met's gets to figure out how to collect it. And have fun with that, Met's. Fucking have fun with that, because the judgment is just a piece of paper. If you want that money in your hand, good fucking luck, son. I've done collections, and it is It is not fucking easy. Not fucking easy. There are steps you have to take, and no, Bunktel says there was for 2 or 3 thousand. Yeah, it wasn't that much money, and Mets can afford to pay it, but Mets won't because he's that kind of guy. Doesn't mean I don't like Mets. I like him. I've talked to him. I was lubricated when I did because I didn't want to be a complete dickhole to him. Um, but when I talk to him, like when you talk to him, he's I'd I'd have a fast food burger with him. I wouldn't take him out for steak. He doesn't have enough teeth for that, I don't think. But a burger, he'd probably gum his way through. So yeah, I'd take him out for a burger and a large side of fries and a large beverage. I would splurge that much on him. Where was I? Uh, All right. It is a familiar practice and an exercise of judicial power for a court upon default by taking evidence when necessary or by computation from facts of record to fix the amount which plaintiff is lawfully entitled to recover and give judgment accordingly, finding that a plaintiff's motion was insufficient to support a default judgment and recommending that the district court conduct a hearing on the plaintiff's motion for default judgment to determine damages. There you go. So then someone, hey Pink, nice to see you. Hope everything's going well for you. And please don't post any more waxing videos. God, someone sent me a link to that and I clicked on it. I don't want that in my life, Pink. I only watched like a few sec once I figured out what was going on. I was like, whoa, I'm not old enough for this. This is too mature for me. So then Metz files an objection to the report and recommendation. Uh, Now comes the plaintiff. He's trying to sound all educated. Uh, George Metz, pro se, to object to the report and recommendation. The facts of the case have been pled in my complaint and backed up with video evidence. There is literally no facts not in evidence in this case. There is literally no facts. Hold on a second. There is literally no facts not in evidence in this case. I think I know what he's trying to say, but I don't think he said what he's trying to say. There's literally, I'm trying to wrap my head around this. I'm sorry. There's literally no facts. There are literally facts in evidence in this case. If you take out the double negative, I think it'd be there are literally facts in evidence in this case. But I think he means there are sufficient facts in evidence in this case. He says the issue seems to be the amount of damages that I'm asking for. And that is not what is at issue. There are two issues that I saw in the report and recommendation. Number one, that you haven't pled sufficient facts to show that you're actually entitled to damages. That's number one. Number two, after you get past number one, if you can get past number one, then the second thing is then establishing the amount of damages you're entitled to. So first, are you entitled to damages? And second, if so, how much? Being that civil rights have no sum certain for violating them, it is up to the judge or jury to award damages they see fit. Well, yes and no. In order to be entitled to compensatory damages, you have to show actual damages. Like, uh, like I was locked up in a jail overnight without probable cause. Well, there's you could say the pain and suffering, and you could make arguments about how much the pain and suffering was worth, and the loss of consortium for that day, and the physical uh, unpleasantness that goes along with being in a jail cell. You could plead all those things, and then then the jury can say, okay, well, you know, you're entitled to some damages on that, but you have to actually show those things. You have to prove those things, and it goes beyond just a mere annoyance. Yeah, the cop kept talking to me. Okay. Cop made threats to me. Okay. Where are the damages? And if you can't show those damages, then you're only entitled to nominal damages. Just because your rights were violated doesn't mean that you get a bunch of damages. You get nominal damages. If you don't show that you were actually harmed, you get nominal damages, which I think you'd be entitled to in this case at best. But then if you could show that the cop in this case acted with malice, or he intentionally violated your rights, if you could show those things, not you said he violated my rights, and maybe he did, maybe he didn't. I don't see that he did, but maybe a court can disagree with me because courts do often. But then you may be entitled to punitive damages, and punitive damages do have a constitutional limit, not just a pleading limit, but a constitutional limit, and they're tied at some multiple of compensatory or nominal damages. And like I said, about $35,000, as far as I know, is about the ceiling, and the cop has to do some really reprehensible shit to get there. So Devin says punitive damages may only be recovered if the trier of fact awards more than nominal damages, or if the claim or claims for which nominal damages are solely awarded invoke privacy rights, property rights, or other rights protected. But yeah, so in this case, it's a 1983 lawsuit. So because it's a 1983 lawsuit specifically, which is what we're talking about here, nominal damage award can get you like up to about $35,000. In normal cases, you're generally speaking not even entitled to nominal damages. You have to actually show damages, compensatory damages, specific or general damages, and uh, and then you're normally, unless a statute otherwise limits it, normally you're entitled to about single digit multiples, up to single digit multiples. So like up to about 9 times whatever you were awarded. 10 times, maybe it's too far. Maybe not. But we know 8.7 times, I think, is the most that the Supreme Court has allowed. But they haven't put a absolute limit to it, because there may be certain situations where it just goes so far beyond the pale that maybe 10 would fly. I don't know. The specific wording is out of Missouri, but even that specific wording, it specifically exempts rights protected by the Constitution, which is the 1983 suit. So there you go. So it's not how they see fit. There are constitutional constraints and and other legal constraints. Like you actually have to prove the damages. If you can't prove the damage, it can't be awarded. If you don't prove the damages, and you get a jury or judgment, whatever, for damages that you didn't prove, then that can get appealed and set aside. There has to be substantial evidence. Now, we also understand the judge or jury could award more than what I was asking. Now, we also understand that the judge or jury could award more than what I was asking for in my complaint. No, they can't, because there's a notice issue there. So the maximum award that you can get in a default judgment is based on the pleadings. So this case is capped out at $200,000. Oh, here we go. Okay. However, in default, I am limited to what I asked for in the complaint. And while no accounting can properly put a price on a violation of rights, I think it is important that our rights are not given away for low judgments that do not deter this or other officers from violating them. Well, I hate to tell you, Mets, but nominal damages are a fairly routine award. $1 is a fairly routine award. That's the court saying, yes, your rights were violated, but you weren't damaged. Have $1. And no attorney in the world is going to chase down a $1 judgment. So whether or not they pay, who knows? They'll probably write you the check right there on the spot or hand you $1 right there on the spot, but ain't nobody going to enforce a $1 judgment. He says, this officer violated my rights every way he could, and without my knowledge, might have violated them more. Well, you're limited by what you pled in your complaint. The display of ignorance shown by this officer, oh my God, Dunning fucking Kruger. Pot calling the kettle black. The display of ignorance shown by this officer only solidifies my hunch that this officer has made a career of violating citizens' rights. Well, your hunch is worth about as much as a fart, dude. Probably less, because people get to enjoy their own farts. How could he not? The defendant knows no laws. He is tasked with enforcing. Well, you allege that you know the law, and you allege that you know that you were allowed to do what you were doing, but that doesn't mean that you were right. So the officer has a different understanding of the laws that he's enforcing, and your hunch is meaningless, and he doesn't have to take your fucking quiz on the spot. Devin asks, if the default wasn't granted, why have a hearing on the potential damages? The default was granted. Defendant is in default. I mean, if he files something, he can get that default set aside. Almost, they almost always set aside. The courts have the courts prefer to have cases adjudicated on the merits. They prefer not to have default. So if he files a motion to set aside default, if the defendant does, it'll probably get set aside. But default was granted. So the issue now, so once the default was granted, then Metz filed a motion for default judgment. People always confuse default with default judgment, and they're two different things. The default, in essence, just prevents the defendant from filing an answer. So now the defendant, in theory, can't file an answer unless he asks the court for permission to file an answer. And it prevents him from really contesting the factual statements made in the complaint. So, at least in California, if I remember correctly, you can still, like, even if you don't contest the default, you can still present evidence at the default judgment stage as to the amount. But I might be misremembering that. So take that with a huge grain of salt. He says, as for damages, it is important to note that the same rule applies today. The restatement second of torts 1979, for example, states punitive damages may be awarded for conduct that is outrageous because the defendant's evil motive or his reckless indifference to the rights of others. Okay, yeah, so they may be awarded, yeah. But that's a general statement. That's not specific to this case. There are other laws that the report and recommendation noted about when the court can grant punitive damages. He continues, most cases under state common law, which this isn't, although varying in their precise terminology, have adopted more or less the same rule, recognizing that punitive damages in tort cases may be awarded not only for actual intent to injure or evil motive, but also for recklessness, serious indifference to or disregard for the rights of others, or even gross negligence. Great. As far as the amount of damages goes, it is also important that the court said in Elrod, the loss of First Amendment freedoms, even for minimal periods of time, unquestionably constitutes irreparable injury. I don't know necessarily what Elrod versus Burns is. I haven't read it that I can recall. Maybe I have, maybe I haven't. But I can tell you that just from that language, Elrod versus Burns is going to be some sort of equitable relief, probably a preliminary injunction or some sort of injunctive relief. And courts prefer damages. Courts prefer giving damages. Money. Money is damages. Courts prefer giving you dollary dues. The courts don't want to spend time making sure and hearing issues about injunctions, trying to adjudicate whether or not someone has violated an injunction or whatever. Courts don't ain't got time for that shit. All right. So if they give you dollars, then you aren't entitled, generally speaking, to injunctive relief. And so what irreparable injury is something that you can't be made whole with dollars. And so what the court is saying, I'm assuming in Elrod versus Burns, and I'm not going to take the time to look it up, but I just know, I am 90% certain that in Elrod, fuck it, we'll look it up. Here's what I'm going to say. In Elrod, there was an issue of injunctive relief, maybe a gag order from a court or something like that, where a court said, you can't say anything about this case until after it's done. I'm guessing, but it's some sort of injunctive relief, and that relates to the First Amendment, and they were suing for injunction, and some lower court, found that there wasn't irreparable injury, and the Supreme Court says there was. Elrod versus Burns. I must have read this before. Yeah, there you go. There you go. Finding that respondents have failed to show irreparable injury, the district court denied their motion for a preliminary injunction. So what this is talking about is a preliminary injunction, not money damages. To get a preliminary injunction, you have to show irreparable injury. So he doesn't. See, this is the thing. Like, he thinks he's really smart, and he thinks he understands these cases. But there are terms of art in these cases that are just obvious to someone who plays around in this field of law. Now, I haven't done a First Amendment case that I can recall, although I have argued First Amendment principles in restraining order cases unsuccessfully, but I told the client it'd be unsuccessful when I started, and they wanted to proceed anyway. So, I mean, hey, at least I told them. Uh, but it's so apparent, and he doesn't know enough to know what he doesn't know, and he doesn't know. Like, he's not educated enough. He's not smart enough to know all the stuff that he doesn't know. Like, I'm smart enough and educated enough to know that I don't know about copyright law. He's so dumb and uneducated that he doesn't know what he's talking about. He cites this for entirely the wrong reason. And that's another thing you'll find with a lot of these really uneducated and ignorant people. I guess that's redundant, uneducated and ignorant. Uh, Ignorant and not so smart people is that they'll oftentimes cite Supreme Court cases for concepts that don't mean what they think they mean and are taken out of context. Sometimes are dicta. But like the entire sovereign citizen movement, like for all the legitimate citations that they use, they're all taken out of context or have been abrogated by subsequent cases or subsequent statutes. So like, and they tend to rely on things taken out of context from Supreme Court cases. Like, they love Supreme Court cases. So how do we put a value on irreparable injury? How do we put a value on rights that folks have died to protect and insure? Well, normally you prove your damages. Every case ever that has a damage award, people have been required to prove their damages, or else are only entitled to nominal damages at most. A low value basically invalidates our rights. I know, but people get nominal damages all the time, as it doesn't provide a deterrent to government officials. Well, it kind of does. And see, that's the point. Once you get that case that establishes it, if they do it again, then you're much You might have only gotten $1 for the case that establishes that they're doing it. But then if they do that again, that's evidence, that's a fact that you could then take to the court and say they're doing this intentionally to deprive people of their rights. Here's the previous case where they did the exact same thing or a directly analogous thing or a very similar thing. And the court spanked them on the hand and gave them $1. Then they did it again. That shows intentionality. That's the point. Now it's on the record. Now it's on the books. If they do it again, maybe you won't get $1. What we do is the plaintiff requests what they believe is the amount the violation is worth to them. Right? That's what you put into your complaint. Now, if it went to trial, then the jury could decide if I deserve more or less than requested. Yes, yes, based on the evidence that you present. But then if it's a summary judgment, then the judge gets to decide what it's worth. You left that part out, Metz. Oh, here we go. However, in a default, my understanding was in a punitive damages case, I would get what was requested in the complaint and not more. Well, your understanding is wrong. And thank you for clarifying to the court that it's a punitive damages case, not seeking nominal or compensatory damages. You've made the job easier. Now, the court may have a lot of grace and may be like, well, I'll still give him the benefit of the doubt, and you may still get your $1. I don't think you'll even get $1. Odds are most likely that he doesn't get anything. Second most likely he gets $1. Third most likely is he gets a small punitive damages award. Small. Poquito. Now the defendant has been given every chance to contest not only the case, but the damages as well. No. Even after granting my default, the defendant still has 30 days in which to appeal that. I don't know that Metz has ever been humble, ask the court to seek justice for the plaintiff in this case and uphold my rights while sending a message that we won't put up with public employees ignorantly performing their duties. You haven't proved that he was ignorant. Any profession is expected to know their profession. A law enforcement officer is tasked with enforcing the law, and while not a lawyer, a basic understanding is required. You haven't proved that he violated the law or that he didn't understand the law. So what would a baseline or basic understanding of the law look like for a law enforcement officer? To test what? We just need to find the law used most often by them in their career. Citation needed. When we realize it is the identification law used multiple times daily throughout their career, we can judge if the defendant has a basic understanding of his profession. Well, if he had arrested you for failing to provide ID, I could understand you saying, well, he didn't have probable cause to arrest me, and there was no law that it was unlawful to provide ID, and the only thing he arrested me for was failing to provide ID, which is not a crime. I mean, then you might have a Fourth Amendment claim. But he didn't arrest you. So maybe that means that the cop knew that he couldn't actually force you to provide the ID, but he could talk you into providing it willingly. And he did. And he provided it willingly. And so now what? Where's the violation? You provided it willingly. Where's the violation? But like, what expert, like what can you cite to that says the ID law is the baseline law that you use to determine whether or not a law enforcement officer knows what he's doing? Like Metz, you don't know shit from fuck. Like, What made you an expert on law enforcement officers? You haven't even pled that you have any experience as a law enforcement officer, and with a felony on your record, I guess you never will. So yeah. After reading the complaint and watching Plaintiff's Exhibit 1, I am sure this knowledgeable and honorable court has come to the same conclusion that I have. Well, two magistrate judges, two, not one, but two, have come to the conclusion that uh, the facts are insufficient to uh, give a damage award in the first place, but also to ascertain that there are any damages. No one raised qualified immunity, Jeff. This is a default issue. So if the officer ever files an answer, then he can raise qualified immunity, but that's an affirmative defense. So two magistrates have said nope, it's insufficient, and the district judge says, well, you've pled enough to put them on notice for some of this stuff, so I'm going to let you serve it. But that doesn't mean that it's sufficient to get a default judgment. That just means that, okay, I'm going to give you an opportunity. If they file an answer and you guys do your discovery and all that fun stuff, then maybe there will be enough evidence. I mean, maybe at least the defendant knows kind of the gist of what you're looking to sue him over. And so, maybe evidence will be developed that at trial, you could establish damages, etc. So, I mean, like trying to say that, I'm sure that the court will come to the same conclusion as me. Like, why? Why are you sure of that? What law can you cite? What what specifically did the magistrate get wrong? Oh, the magistrate missed this case. The magistrate missed that case. Oh, you don't have anything. This is a family law pleading, a pro se family law pleading. Defendant doesn't know the basics of his profession. You haven't shown that. And shows as much in Plaintiff's Exhibit 1 with statements, quote, anytime an officer asks, you must provide ID, end quote. Well, the court knows, you know, I know, and Metz knows, except he conveniently forgets it for things like this, that officers can, will, and do lie to you. And my favorite, quote, you have to provide physical ID, end quote. He says both statements are knowingly false. Yes, officers can lie to you. Officers can lie to you. That's not a violation of your rights. I don't know why you don't get that. They can do a lot of dumb things. They can say things like, if you don't give me permission to search your house, I'm going to go get a search warrant and I'm going to arrest you. They're trying to convince you to give up your rights because if honestly, like my best hunch is that if they had fucking enough to get a search warrant, they'd just get the search warrant. Both statements are knowingly false. No fucking shit, dude. Which begs the question, does the defendant not know the law or does he just disregard it? What law prevents him from lying to you? What law prevents that cop from lying to you? Either it is either either is unacceptable for a law enforcement officer at the rank of deputy chief who has most likely 10 or more years on the job. The officer knows he can lie to you. It's not illegal for a cop to lie to you. The cop lied to you. The reasons mentioned above and the fact that we established government to protect, not violate rights, we humbly ask the court to grant our motion for default judgment in the amount requested and let the defendant contest it in an appeal if he disagrees. Well, my best guess is that the district court will construe this as an opposition, will look at it very carefully, try to glean anything out of it as possible, and then most likely set the matter for a hearing, just to give Met every opportunity. My best guess is that the district court is going to set it for a hearing. to give Mets the opportunity to prove something. Uh, Second most likely is the court is going to adopt the report and recommendation of the magistrate because there's nothing there. There's nothing in the complaint. Like the cop lied to you a couple times and talked to you for a while. He didn't arrest you. He didn't do anything. He told you to turn off your camera, but you kept recording, so he didn't actually prevent you from recording even. And he didn't arrest, like, he said he'd arrest me if I didn't turn off my camera. Well, put that shit to the test. He still recorded. Anyway, anybody have any questions, comments, or concerns on that? All right, well, chat team's dead, and so anyway, I guess that's going to be it for today. Thank you very much for watching, and have a wonderful day.